Now let's talk about an indispensable party. Who is an indispensable party? An indispensable party is a real party in interest without whom no final determination can be had of an action. So the rule is parties in interest without whom no final determination can be had of an action shall be joined either as plaintiffs or defendants. A joinder of an indispensable party is mandatory. The presence of all indispensable parties is a condition sine qua non for the exercise of judicial power. So what happens when there is a non-joinder of indispensable party? The non-joinder of indispensable parties is not a ground for the dismissal of an action. The remedy is to implead the non-party claimed to be indispensable. Parties may be added by order of the court on motion of the party or on its own initiative at any stage of the action and or at such times as are just. If petitioner refuses to implead an indispensable party despite the order of the court, the latter may dismiss the complaint or petition for the plaintiff's or petitioner's failure to comply therewith. This is under Rule 17. So here is an illustration. If an indispensable party is not impleaded, the court shall order such party to be impleaded either through a motion of a party or on its own initiative. It is when the order of the court to implead an indispensable party goes unheeded may the case be dismissed under Rule 17 for failure to comply with the order of the court. Let's discuss the case of heirs of spouses Messina represented by Norman Messina versus heirs of Fian represented by Iray et al. This is a 2013 decision of the Supreme Court. The facts in this case are as follows. The late spouses Faustino and Genoveva Messina, during their lifetime, bought from the spouses Domingo Fian Sr. and Maria Fian 2 parcels of land on installment. Upon the death of the spouses Fian, their heirs, whose names do not appear on the records claiming ownership of the parcels of land and taking possession of them, refused to acknowledge the payments for the lots and denied that their late parents sold the property to spouses Messina. Meanwhile, spouses Messina passed away. Notwithstanding repeated demands, the heirs of Fian refused to vacate the lots and to turn possession over the heirs of the spouses Messina, namely Norman, Victor, Maria Divina, and Lorna. On August 8, 2005, Norman, as attorney in fact of his siblings Victor, Maria, and Lorna, filed an action for quieting of title and damages before the regional trial court in Baybay Leyte against the heirs of Fian, naming only Teresa Fian Iray, Teresa as the representative of the heirs of Fian. The case was entitled Heirs of Spouses Faustino S. Messina and Genoveva S. Messina, represented by Norman Messina, versus heirs of Domingo Fian Sr., represented by Teresa Fian Iray, and was docketed as a civil case. Respondent Teresa filed a motion to dismiss the complaint, arguing that the heirs of Messina could not be considered as a juridical person or entity authorized by law to file a civil action. Neither could the heirs of Fian be made as defendant, not being a juridical person as well. She added that since the names of all the heirs of the late spouses Messina and spouses Fian were not individually named, the complaint is infirmed, warranting its dismissal. The RTC dismissed the complaint, ruling that the rules of court is explicit that only natural or juridical persons or entities authorized by law may be parties in a civil action. In affirming the RTC, the Court of Appeals held that all the heirs of the spouses Fian are indispensable parties and should have been impleaded in the complaint. The appellate court explained that this failure to implead the other heirs of the late spouses Fian is a legal obstacle to the trial court's exercise of judicial power over the case, and any order or judgment that could be rendered is a nullity in view of the absence of indispensable parties. So the issue in this case is whether or not the dismissal was proper, whether or not the heirs of Vian are indispensable parties to the case. The Supreme Court held that as regards the issue in failure to state a cause of action, the Court of Appeals ruled that the complaint states no cause of action because all the heirs of the spouses Vian are indispensable parties, hence they should have been impleaded in the complaint. The CA, affirming the RTC, held that the dismissal of the complaint is called for in view of its failure to state a cause of action. Failure to state a cause of action refers to the insufficiency of the pleading. A complaint states a cause of action if it avers the existence of the three essential elements of a cause of action: the legal right of the plaintiff, the correlative obligation of the defendant, and the act or omission of the defendant in violation of said right. Okay? By a simple reading of the elements of a failure to state a cause of action, it can be readily seen that the inclusion of Theresa's co-heirs does not fall under any of the above elements. The infirmity is in fact not a failure to state a cause of action, but a non-joinder of an indispensable party. Now, what is the effect of the non-joinder of an indispensable party? The court held that non-joinder means the failure to bring a person who is a necessary party, or in this case an indispensable party, into a lawsuit. An indispensable party, on the other hand, is a party in interest without whom no final determination can be had of the action, and who shall be joined either as plaintiff or defendant. As such, this is properly a non-joinder of indispensable party. The indispensable parties who were not included in the complaint being the other heirs of Vian, and not a failure of the complaint to state a cause of action. Having settled that, the Supreme Court held that in the pronouncement in Pamplona Plantation Company versus Tinghil is instructive as regards the proper course of action on the part of the courts in cases of non-joinder of indispensable parties. What is it? The non-joinder of indispensable parties is not a ground for the dismissal of an action. I repeat, the non-joinder of indispensable parties is not a ground for the dismissal of an action. At any stage of a judicial proceeding, and or at such times as are just, parties may be added on the motion of a party or on the initiative of the tribunal concerned. If the plaintiff refuses to implead an indispensable party despite the order of the court, that court may dismiss the complaint for the plaintiff's failure to comply with the order. The remedy is to implead the non-party claimed to be indispensable. Thus, the dismissal of the case in this case for failure to state a cause of action was improper. What the trial court should have done is to direct petitioner Norman Messina to implead all the heirs of Domingo Vian Sr. as defendants within a reasonable time from notice, with a warning that his failure to do so shall mean dismissal of the complaint. Okay, let's discuss another case, Divina Gracia versus Parilla, GR number 196750, March 11, 2015. The issue in this case is whether co-owners are indispensable parties in an action for judicial partition. The Supreme Court held that an indispensable party is one whose interest will be affected by the court's action in the litigation, and without whom no final determination of the case can be had. The party's interest in the subject matter of the suit and in the relief suit are so inextricably intertwined with the other parties that his legal presence as a party to the proceeding is an absolute necessity. In his absence, there cannot be a resolution of the dispute of the parties before the court which is effective, complete, or equitable. Thus, the absence of an indispensable party renders all subsequent actions of the court null and void for want of authority to act, not only as to the absent parties, but even as to the present. With regard to actions for partition, Section 1, Rule 69 of the Rules of Court requires that all persons interested in the property shall be joined as defendants. Thus, all the co-heirs and persons having an interest in the property are indispensable parties. As such, an action for partition will not lie without the joinder of said parties. In the instant case, records reveal that Conrado Sr. has several heirs, legitimate and illegitimate, who are entitled to a pro indiviso share in the subject land. The omission of the heirs renders his complaint for partition defective. Now what happens? The Court of Appeals erred in ordering the dismissal of the complaint on account of Santiago's failure to implead all the indispensable parties in his complaint. In Heirs of Messina versus Heirs of Fion Sr., the court definitively explained that in instances of non-joinder of indispensable parties, the proper remedy is what? To implead them and not to dismiss the case. The non-joinder of indispensable parties is not a ground for the dismissal of an action. At any stage of a judicial proceeding, and or at such times as are just, parties may be added on the motion of a party or on the initiative of the tribunal concerned. If the plaintiff refuses to implead an indispensable party despite the order of the court, that court may dismiss the complaint for the plaintiff's failure to comply with the order. The remedy is to implead the non-party claimed to be indispensable. In view of the foregoing, the correct course of action in the instant case is to order its remand to the RTC for the inclusion of those indispensable parties who were not impleaded and for the disposition of the case on the merits. Next case, People v. Gon de la Rosa, GR number 21644, September 24, 2014. In this case, 7 informations were filed against various accused, including Go and de la Rosa, charging them of estafa. After numerous postponements, respondents were finally arraigned and trial on the merits then ensued. However, the trial of the case was marred by a series of postponements or cancellation of hearings caused mainly by the prosecution. Respondents filed a motion to dismiss for failure to prosecute and for violation of their right to speedy trial. The RTC dismissed the criminal cases. In a motion for reconsideration, the RTC reinstated the case. Respondents filed a petition for certiorari before the Court of Appeals. A copy of the petition was served, however, only on the private complainant, that is, the PDIC, and not the people of the Philippines, or the people through the OSG, as it was not even impleaded as party to the petition for certiorari case. In a decision, the Court of Appeals, without first ordering the respondents to implead the people, annulled and set aside the assailed orders of the RTC and consequently dismissed the criminal cases against respondents. The central issue to resolve is whether or not the criminal cases against respondents were properly dismissed by the Court of Appeals and certiorari without the people as represented by the OSG having been impleaded. The Supreme Court held that respondents' certiorari petition that sought the dismissal of the criminal cases against them should not have been resolved by the Court of Appeals without the people as represented by the OSG having first been impleaded. This stems from the recognition that the people is an indispensable party to the proceedings. In the case of Banguera versus Rizos, where the petition for certiorari filed with the Court of Appeals failed to implead the people of the Philippines as an indispensable party, the court held that it is undisputed that in their petition for certiorari, respondents failed to implead the people of the Philippines as a party thereto. Because of this, the petition was obviously defective. As provided in Section 5, Rule 110 of the Revised Rules of Criminal Procedure, all criminal actions are prosecuted under the direction and control of the public prosecutor. Therefore, it behooved the petitioners to implead the people of the Philippines as respondent in the case to enable the Solicitor General to comment on the petition. Okay, so while the failure to implead an indispensable party is not per se a ground for the dismissal of an action, considering that said party may still be added by or order of the court on motion of the party or on its own initiative at any stage of the action, and or such times as are just, it remains essential, as it is jurisdictional, that any indispensable party be impleaded in the proceedings before the court renders judgment. This is because the absence of such indispensable party renders all subsequent actions of the court null and void for want of authority to act, not only as to the absent parties, but even as to those present. In this case, it is evident that the Court of Appeals proceeded to render judgment, that is, the decision and the resolution, without an indispensable party, that is, the people, having been impleaded. Thus, in light of the discussion, these issuances should be set aside and the case be remanded to the Court of Appeals. Consequently, the Court of Appeals was directed to reinstate respondents' certiorari petition and to order said respondents to implead the people as a party to the proceedings and thereby furnish its counsel, the OSJ, a copy of the aforementioned pleading.